Hello, and welcome to another exciting episode of the Law Lab. Here we dissect and unpack everything legal. My name remains Aaron Asiedu-Entry, your favorite host, I guess. And today I have with me Mr. Ben Mahmoud Adamu again to help us. I think on the previous episode, we were looking at public international law, the introductory part of it. He actually helped us to appreciate what public international law is, and also help us differentiate between public international law and municipal law and that of private international law. I think we looked at some few cases where we looked at Banfo and Henry Nana Boakye. We mentioned that Henry Nana Boakye is the incumbent MPP's national organizer as against the Attorney General and Minister of Interior.
Foreign Affairs.
Foreign Affairs, yes. Okay. That's right. Okay, so today, we all know that when you pick your Constitution 1992, when you pick the bigger one, you go to page 10 or chapter 4, you see Article 11, that will provide the sources of law in Ghana. That is the municipal laws in Ghana, the sources of it. Now, today, what we want to look at is, are there sources of public international law? And if there are sources, do we have a defined source of public international law? That is what Mr. Ben Mahmoud is going to help us. So, today we are looking at sources of international law.
Yes.
And do we actually have a settled source of public international law, or we are only presuming that there is a certain source of public international law?
Right. Thank you very much, Aaron. And I must say that I am happy to be back here with you today to continue the series we've started in public international law.
Very well.
Now, to the question that you have asked, yes, there is a determinable source of international law, or the sources of international law, which the International Court of Justice would turn their attention to when there's a dispute, before them to settle. Now, the International Court of Justice was established by the United Nations in one of their resolutions to be the court that would settle disputes that arise between nations, or disputes that arise in the international.
So dispute between Ghana and Togo.
Yes.
This one we can just settle it up alone.
We can sit around the table and
just have
some small gin and close it out.
Yes,
we can. But there are some disputes which would have to go beyond arbitration, which, a court would have to sit down and make certain pronouncements.
I think a clear case happens with Ghana and Ivory Coast on the sharing of the Mediterranean border.
Exactly.
The sea border,
exactly. And many other disputes that the court can settle on. Additionally, the UN set up the ICJ. When I say the ICJ henceforth, I'm referring to the International Court of Justice.
Okay.
They established the ICJ to also advise the United Nations on legal matters as they may forward to them, from time to time to look at. And so the sources of international law, reference would be the statute of the International Court of Justice.
So the UN set up ICJ. ICJ also have statutes.
Exactly.
Okay.
All right.
I think even in our system, we have the rules of court committee that comes out with all rules and others. So I remember in 2012, when we had this election petition, it traveled for about 8 months into 2013. I think until about August before there was a determination.
Yes.
In 2020, Justice in CJ, as he then clearly came out with this, together with the rules of court committee, said that we are not spending over 2 months on presidential election disputes. So I think that is the same case for the ICJ.
Very similar. So the statute of the International Court of Justice is what establishes the statutes, the court itself. All right. So the ICJ would give the courts the powers that they have to settle disputes and advise the UN as we previously mentioned.
Okay.
And in establishing the court, the United Nations gave it a set of rules that they should consider in determining cases that are brought before them, right? And so it is the statutes that we'll be turning to identify the sources of international law which would be important for us.
So basically, all that you are saying is that the UN set out the ICJ, the International Court of Justice, and set out the statutes that anytime there is an international dispute, refer to that statute in adjudicating the matter.
Exactly.
Right?
Yes. Right. So the statutes gave it the ICJ the powers that they have and all of that. And some, for want of a better expression, terms of reference for the duties that they have as a court.
Or scope of work.
Exactly.
Sure.
Exactly, yeah. Now, Article 38 of the Statute of the International Court of Justice spells out the sources of law that they have identified, or that's those sources of law which they have agreed, to have some effect on the decisions that they make, going forward. And so Article 38(1) of the Statute of the International Court of Justice will provide as follows. The court, whose function is to decide in accordance with international law, such disputes as are submitted to it, shall apply, and it gives the following. A, international conventions, whether general or particular, establishing rules expressly recognized by the contesting states. Right? This generally we refer to as treaties. And later when we get into, the subsequent episodes, I'm sure we'll have the opportunity to discuss these sources of law in much detail. All right. The second paragraph, or paragraph B, would go on to say that international custom as evidence of a general practice accepted as law. So again, the court is identifying that international customary law would be another important source of law for the ICJ. The third paragraph will say that the general principles of law recognized by civilized nations. All right. So these may not necessarily be codified laws, but they are principles of law or maxims of law which, are generally accepted across the globe as being binding or persuasive for judges in making determination of disputes that are brought before them. And the last but not the least is subject to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of rules of law. What this, in simple terms, is referring to is that previous decisions of the courts itself would be binding on, future cases that the courts would have to settle. Again, the courts will be influenced by writings of scholars, the likes of Malcolm Shaw, Damroff, and a few others.
I think the court
would influence them in making their decisions.
The court should consider one of my mates that I completed law school with. He's called Divine Salu.
Right.
We call him the IGP, Inspector General of Petitions. That gentleman has a lot of petitions. Even as we are speaking now, as he has petitions in his pocket. All he needs is to just edit it and put some names in it.
Right.
I think we'll be coming back to the last paragraph so that when you're explaining it, you take us through whether it is binding or not and others. Just for purpose of education, you heard Ben mentioning paragraphs and others. Remember that in our first edition, that was actually speaking about how to read the Constitution, that we read it from articles to clauses to paragraphs. Same way or same applies to this very situation. So Article 38, Clause 1, Paragraph A, Paragraph B, Paragraph C, and you move on. Remember that I said that when you are reading an act, it starts from sections, subsections, and you move in the same order. But with the ICJ statute, just as we read in our Constitution, that we start from article to clause to paragraph. It is same applies to this very situation. Now, Mahmoud, we learned in various law schools, various constitutional law and legal system classes that when you are looking at the sources of law, it's in a hierarchy. In the sense that Article 11 of Constitution 1992 is providing that you have basically 5 sources of law. Looking at the Constitution, Act of Parliament, subsidiary legislation, existing laws, and the common law of Ghana. I mostly repeat of Ghana for us to appreciate that we are not looking at basically the common law. Because when we talk of common law of Ghana, we are looking at 3 things. First, the normal common law, you know,
Yes.
you look at the doctrine and rules of equity
Yes.
and also customary law. So that forms, these three things forms the common law of Ghana. We are saying that anytime the constitution is being mentioned or there is a provision, it takes precedence over any other law, as clearly spelled out in Article 1, Clause 2 of the Constitution, that
Yes.
the Constitution shall be the supreme law of the land, and any other law found to be inconsistent to the extent of that inconsistency shall be void. Are we looking at similar effects of the Constitution in the ICJ Statute, that any time that there is, let's say, these sources of international law, being it treaties, customary international law, general principles as recognized by general principles of law as recognized by civilized states, and also judicial decisions and writings by highly qualified publicists. Is it also in a hierarchy format, or is it hierarchical?
Thank you very much. There isn't any straightforward answer to this question that you have asked. If you comb through the statutes of the ICJ, as we have seen, it does not emphatically mention that the sources of law have been arranged in any order in particular. However, I think that when you go into the details of what all of these things stand for, we would realize that treaties and international agreements are voluntarily entered into, all right? And so there's that freedom of contract, all right? So there's the freedom for the parties to determine what they want to be bound by and not. It would stand to reason that treaties and international agreements would have some sort of supremacy. If there is a treaty that treats or that speaks to the disputes that the court is looking at, it will then stand to reason that if you have voluntarily committed yourself to these provisions of the treaty, then you should be bound by them. And so I would think that yes, treaties would have to be number one, or then the highest form or source of international law.
So in law of contract, there is this case, is this Corte versus Noga. It looks at implied custom into an agreement, looking at how people actually behave. Then the court would impute that, okay, per this agreement, looking at the custom or the trade you are in, we are going to impute that law or that custom into your agreement. What you are trying to make us understand is that when there is a custom, even when it is recognized on a disputed matter, and there is a treaty that is speaking to that disputed matter, the court is going to consider the treaty ahead of the customary international law, right?
Yes, absolutely the case that I am making. All right. It is only in the instance where there is not an existing treaty which the disputing states are party to, which speaks to the matter that they are both contesting in the courts, then the court would have to avert its mind to other sources of international law. And we've mentioned that one of those is international customary law. The caveat with international customary law is that paragraph B of section 38, Article 38, clause 1, would go on to say that as evidence of a general practice accepted as law. So it's not just any customary international law that is any international custom that the courts will look at. It must have reached or received the recognition as law between the parties, so that the states that do them are doing them not as a matter of custom anymore, but as a matter of law. And we'll get into those details.
Sure. I would want us to actually pick it one by one by treating treaties very well. But just as you are looking at customary international law, I just remembered one thing that I was taught in constitutional law when we were looking at evolutions of constitution. I believe our lecturer in looking at the case of Angu versus Atta actually mentioned that some customary activities must gain notoriety before the court, where Mensa Saba and other jurists actually spoke against such thing that evolved by
the courts must take judicial notice of them.
So against notoriety. But okay, so clearly, the first source of international law we must look at and understand due to the principle of freedom to contract. You know that because of the principle of freedom to contract, it is why we say consideration needs not to be adequate. because what you accept as a consideration
Absolutely.
shouldn't be a matter of the court. And so if you freely enter into an agreement, then clearly that treaty or an agreement should take some sort of precedence because that is what you've accepted. So that is it for treaties and customary international law. I think when we are looking at customary international law, we would actually look at the scope or to what extent would we say a certain custom has gained that notoriety before the court and it's been recognized.
Yeah.
I think when I was being taught customary international law, I remember one of the examples that was given us is the red carpet that we lay for heads of state
when they arrive at the
because
airport.
when I just asked myself, so if there is no red carpet being laid, would that be some sort of breach of an international law and others? And I
Right.
think that would perfectly sink or sit in the customary international law.
Yeah.
The third form of or source of international law as provided by the International Court of Justice Statute, Article 38, 1C, that is general principles of law accepted by civilized state. But which country is not civilized?
Good question. Right. No, so what Article 31C is referring to really are, before there was, codified constitutions and laws and all of that, there were those things that regulated human activity or human life without necessarily having the effect of law, right? Now, as law has developed and codified statutes and constitutions have come in, these principles undergird the laws as have been passed, right? Principles like, natural justice, everybody has to be heard or given the opportunity to be heard in their own case and all of those things. Principles like pacta sunt servanda, that anybody who enters into a contract must perform their obligations that they have really
I think that would
accepted.
even affect the boys. Those who enter into contract with ladies to propose to them. Is that actually a contract?
That is a matter to be discussed.
I think it affects you. It affects you. You'll be facing a lot of seats.
I'm sure that is an interesting topic to be discussed.
I have this friend. He's called Darlington Cranton Entry. I think when it comes to such situations, we would need
his expertise,
highly qualified publicists to be defending him. That guy is a trouble guy. Right. We need the Inspector General of Petitions. Divine Salu. Tell that guy can petition. Hey.
Right.
I think he needs some statue at the Gimpa Law Faculty for the number of petitions and advocacy he's led.
He's contributing to the development of law.
He says we are conquering the law together. Wow. So on general principles of law.
Right. So these generally accepted principles, which, like I've mentioned earlier, undergird, legal jurisprudence across, nation states, are things that the court will also avert their minds to when they are making decisions or determination on matters that have been brought before them.
Okay, I think the last one we'll be looking at, and probably in our next episode, we'll be taking the sources of law one by one so that you explain it into detail. Moving on to judicial decisions. When you come to our system, when you come to the state Ghana, mene Ben or mene say Daniel, enya problem. We have an issue before the court. It is resolved due to the principle of stare decisis precedent.
Yes.
If the same issue or similar fact, there is an issue between Ama and Kofi, it is going to be applicable. Yeah. Are these judicial decisions or what we are even talking about?
Yeah.
Is it the same case that principle of stare decisis is being implemented in the judicial decisions?
Right. Okay. Again, there isn't a very straightforward answer. I think that what we must understand in judicial decisions is that there are some decisions which are binding and those that have persuasive effect. All right. It is not binding, but it would influence the court in what decision it arrives at. Now, when there is a case between two parties, which, in a previous matter had been decided by the court, then such a decision will be binding. So in the example you gave, for example, if there's a case between state Ama and state Kofi had been adjudicated upon, say, 3, 4, 5 years ago, there's a new matter, facts are very similar to that one. Then in that new case between state Kofi and state Ama,
same
parties,
okay.
It would be binding. However, if it is state Kojo and state Seyao, subsequently, the previous decision between state Kofi and state Ama will not be necessarily binding, but would only have persuasive effects. Persuasive effects meaning that the court is not bound to follow the decision they made there, but it has the capability to influence what decision they make in that matter.
Then this international law, the common law countries will be suffering because they are used to precedent. And so they will be quoting a lot of precedent. They will go there, and the civil law countries will be benefiting more, or be having more, some advantage because they are looking at
but like we mentioned, if a case has persuasive effects, it can make your argument even stronger.
It can only make the argument stronger.
Exactly, yeah.
But when it comes to precedents, you are forcing the court to take that, unless they actually go by the 3 ways. I think when we look at our judicial precedents episode, when we're explaining that, you get to know that in common law countries, you need to follow the precedent. However, in 3 circumstances, either of the 3, you can actually depart from the precedent, being it the judge distinguishing between the facts. 2, the case was determined per incuriam, where per incuriam we are saying that the judge did not consider a certain material fact or did not apply a certain law that would have changed the decision of the case. And the 3rd circumstance is when there is a changed circumstance. You know, we are in a Gen Z era. We are in a digitized era, a digitalization era. What happened in 1992, there was no TikTok. Today, we are having TikTok. So there are some changed circumstances that judges can base on not to follow precedent. Mahmoud, I think it's been an exciting one running us through Article 38.1, specifically on the sources of international law. I believe that in our next episode, you take your time to run us through these sources of law, one after the other, to appreciate it so well. Thank you very much, ladies and gentlemen. This has been the Law Lab. We've considered the sources of law. Remember, I've always been saying that do not take all your matters to God. Take some to your lawyer. Thank you very much, and see you in our next episode.